Good morning, everybody. I'm Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I'd like to dive right in. The first thing I want to talk to you all about are my international students. So, I've been talking a lot about international students recently. Today is no different. So, in general, I like to dive right in. So, in general, international students are not given a specific time by which they have to complete their degree from an immigration perspective. When they enter the U.S., their I-94 cards, which as an aside, you should all be checking when you enter the U.S. to make sure that they're accurate. But an international student's I-94 card is marked with D/S, or David/Sam, D/S, which means duration of status. And so that gives an international student flexibility, and it makes it easier for them to finish their degree, add on extra classes if they need to, take more time to complete their degree, or roll into a second degree. So maybe they go straight from a bachelor's degree to a master's degree. Most non-immigrant folks, when they enter, their I-94 card has a specific date by which they must leave the U.S. International students don't have a specific date. They have D/S. So it's just flexible. And frankly, it's really flexible for folks at CBP, at the airport. It means they don't have to do all this coordination with the schools and CVIS and ICE and all of the other agencies involved. And so D/S also makes it very convenient for schools to continue to update I-20s for their international students. Well, DHS has begun the process to publish a rule that would essentially change and no longer allow D/S to be appropriate. And now they are looking at wanting fixed times by which the education program must be completed. So to be clear, and to sort of bring us back a little bit, this was first attempted in 2020. And the educational institutions strongly opposed this move to get rid of D/S. And so in 2021, this issue was abandoned. So we are now seeing it come back. It is coming back under the exact same name that it was released in 2020. So getting rid of D/S and getting rid of that flexibility will cause the students to have to go back, more coordination with the schools, more amended I-20s, potentially may make the mechanics of getting a new, forcing students to get a new visa when they go home. So a whole host of things can potentially come out of this. One of the big things that can come out of this is when there is a specific date, when someone overstays a specific date written on their I-94 card, that is when unlawful presence starts to accrue. As of right now, our international students are not accruing unlawful presence if they stay past the time when their program has ended. If there is a specific date on their I-94 card and not DS, they will most likely begin to accrue unlawful presence. So this is sort of a big shift in the international student landscape. We'll keep you updated on this as this new rule winds its way. It's only at the beginning, but as it winds its way through the system to become a regulation. So nothing has changed just quite yet, but I wanted to give you a heads up that this is coming, we think, assuming they don't abandon it like they did the last time, but I'll keep you updated on this. Next thing I want to talk to you about is H-1B cap season. So everyone that was selected at the end of March of this year, your H-1Bs should have been filed by June 30th. There was an extension for online filings to July 1, but only for online filings. So if you have not filed, unfortunately, you are no longer eligible to file. So now we wait for USCIS to count and do all the numbers and see if they have enough applications in-house that they think they will meet the cap. If they do think they have enough applications to meet the cap, then cap season is over. If they do not think they have enough applications in-house to meet the cap, then they will run a new lottery. But the new lottery, if it is run, big if it is run, the only folks eligible for that second lottery would be people that put in for the first lottery back in March. So if you didn't put in for the first lottery that was run back in March, you cannot put in for a second lottery if we have a second lottery, and we don't know that yet. So we're still waiting for CIS to do all of the counting. So I will keep you updated, of course, if there is a second lottery. But as of right now, I haven't heard anything. Nothing's been officially released. Next thing I want to talk to y'all about is temporary protected status, or TPS, for nationals of Haiti. So DHS announced that they were ending TPS for Haiti, but in doing so, they cut the time short from 18 months to 12 months. A lawsuit was filed in federal court. It's been winding its way through federal court, but a federal judge recently ruled that DHS went beyond its authority. They did not go beyond their authority in canceling and terminating TPS. It was the way that they went about canceling it. So what the federal court judge said was essentially, you can end TPS, but you have to follow the rules when you're ending it. And so the rules say 18 months, not 12. So we are now essentially back to an 18-month time frame, which sets TPS for Haitians to end February 3rd, 2026. That said, it's kind of expected that DHS will appeal the federal judge's ruling. So keep your ear to the ground on that. We will keep you updated. But to be clear, the federal judge did not say that DHS could not terminate TPS. They just had to follow the process that's in place in order to terminate TPS. So as of right now, TPS for Haitian nationals is ending February 3rd, 2026. So with that said, if you are a Haitian citizen and you are on TPS now in the US, now is your time to look for a plan B. Look for a plan B because it's fairly clear that DHS wants to end TPS. It's just that they haven't done it correctly. So you've got a little bit more time there. If you are an employer of an individual who is Haitian and has TPS, now is the time to help them evaluate if they have a plan B. Now is time to evaluate your own plan B if they unfortunately cannot remain employed with you. So everybody who is impacted by the ending of TPS should be evaluating their plan B. What is your next step? So if you need help with that, let us know. We're happy to schedule a consultation with you and see what we see in your individual case. And please remember, just because your friend, your associate, or your colleague has a plan B in place, that does not mean that their plan B will be your plan B. Everybody's situation is different. Next thing I want to talk to you about is the medical form. So when you're applying for a green card, you have to go through a medical exam. That medical exam, you take a form. Sometimes a civil surgeon has the form. You can also take the form. You can download it off the USCIS website, take it to your appointment with you. That form then is sealed and provided to the Immigration Service. As of July 3rd, so a couple days ago, there is a new form addition. So make sure, if you've already had your appointment, but you have not gotten your form completed and back yet, make sure that your civil surgeon uses the updated form because you don't want your entire application denied or coming back to you or getting an RFE because the correct form wasn't used. So just gently remind them that there was a form change, that there was a form update. The new rule also, or the updated form, now limits the form's validity to be used only for the application for which it was originally filed. So no using that same medical for subsequent applications. So keep that in mind as well. And the last thing I want to talk to you all about this morning are wet ink signatures on forms. So during COVID, USCIS and DHS decided that they would accept scans of wet ink signatures. It was COVID, there was social distancing, people were working from home, it was a whole new world, it was very unprecedented. And frankly, pre-COVID, USCIS was not hearing anything about scanned ink signatures. But during COVID, they were like, okay, we're gonna release these reins a little bit. We're gonna allow scans of wet ink signatures. So great, we did that during COVID. Then after COVID, presumably because USCIS and DHS found this convenient and efficient, it became the law of the land. It became the policy that USCIS would accept scans of wet ink signatures. CIS will not accept an electronic signature. So, and when I say electronic signature, I mean where you type your name and there's language below that says by typing your name, and you can choose a cursive font, you can choose a fun font, whatever. USCIS does not like that, and they have never liked that, and that has never been a policy even during COVID. What I'm talking about is you take a pen, you write your name down, and then you scan that wet ink signature. But you got to wait a minute before you put it through some scanner so that it won't just completely smear. Those wet ink signatures are what I'm talking about. So after COVID, USCIS and DHS said, yes, we will let you now and forevermore submit scans of wet ink signatures. Well, it would seem maybe this is a training issue. I don't know. Maybe they're trying to walk it back. I'm not quite sure. However, colleagues have recently been seeing they have been getting rejections, and your application is rejected from the mailroom. So it will be rejected, whole thing sent back to you and said, essentially, you had an electronic signature, you didn't have a wet ink signature. Or we've been seeing RFEs issued for lack of proper signature. So this is an FYI. Make a decision how you wish to proceed with your application, whether you want to go all the way backward to wet ink signatures and getting those forms from folks and sending those in, or whether you want to still use scans of wet ink signatures. If you are going to use scans of wet ink signatures, make sure that you maintain the original signature page in case USCIS later asks to see the original signature. So that is all I have for us this glorious Monday morning. If you have any questions about your case, your employment-based case, the strategy, the addition of the form, do you have a plan B if you're not, if there isn't a second H-1B lottery? Do you have a plan B if you're currently a Haitian national with TPS that is about to expire? Feel free to reach out to us. We are happy to set up a consultation and have a conversation with you. Have a great rest of your